So I am working on a Supreme Court file right now, my own. I'm bringing a file that I'm appealing from the Ontario Court of Appeal. And I'm going to walk you through a little bit of the introductory stuff here on the Supreme Court of Canada's website. So there's a lot of things that they offer as far as guides and access to the rules and the Supreme Court Act. All of this is great information. You're probably going to find yourself more over here in the resources section if you're a self-represented litigant. But it's also good to take a look at the rules of the Supreme Court, rules of the Supreme Court of Canada, and the Supreme Court Act. So this is just, in making this video, I went through at another time and I made the screenshot video that you're watching, and I'm narrating this afterwards. So I'm not exactly sure as to what it is that I clicked on at specific times. Application for leave to appeal, I am going to probably do a whole separate video on this. But essentially, most files that go to the Supreme Court of Canada have to go through a process of applying for permission to appeal. So typically what they advertise on their website is that the applications that they receive amount to about 600 applications per year. And they only hear about 80 appeals per year. So that means, you know, somewhere in the 10% range or what have you, less than 10% of cases that ask for permission to appeal actually get to appeal. So it's not a guarantee coming to the Supreme Court that you can appeal your case. Anyway, this is taking a look at the rules, and it's good to note that the application for leave to appeal is it's not a complex process, but it's something that needs some time and dedication. It's also good to note there's obviously fees and costs that are payable to the registrar. So Schedule A here, if I think I look at Schedule A, if you're a self-represented litigant, obviously you're a self-represented litigant for a reason, and it's good to take a look at what fees are going to be due at minimum. At minimum, you're going to be able to find an application for leave to appeal costing you $75. Under Schedule A there, though, you have what is called a fee waiver is available to persons who have quote-unquote special cases. So essentially what the court looks for is a 2-page letter that you include with your application when you're filing it after you've already served it, your application for leave to appeal, I should say. And they look for a 2-page letter for you setting out why it is that you believe the registrar should give you a fee waiver. So that is not something that the court readily advertises, but it's good to know. So what's good to also know is that right when you start off, you're going to be needing to make at least 6 copies of your materials. So my materials amounted to 63 pages, and that translates into one set of 63 pages going to the other side, so the lawyer that I'm serving on the other side, one set of these 63-page documents. One set goes to the Attorney General of Canada. One goes to the Attorney General of Ontario. Six are now going to the court. So that is 9 copies right off the bat, 63 pages each, that I have put together. And I'm going to make a video of my application. I'm going to censor out some of the details. So here's the fee, the $75 for notice of application for leave. Is $75. If you want to file a motion, it's $75. I don't know why you'd want to be making photocopies, but maybe if you're photocopying out of your own file, I guess. That's $1 a page. That's kind of standard. So the fee does not apply to a notice of application for leave to cross-appeal. So a cross-appeal, a notice of application for leave to cross-appeal, is the other side essentially saying that they want to appeal after the file has already been started. It's also good to note that all of the Supreme Court hearings are videotaped. So if you want to obtain a video recording or an audio recording of a Supreme Court hearing, that's something that can be done. All this is found through the Supreme Court of Canada's website. And here we go. Any person may be exempted from paying any of the above fees in special cases at the registrar's discretion. And, what makes up a special case? Probably showing that the application is without, that the application is with merit to some degree. And then, whether or not the registrar will assess that is another story. Showing that there's financial need and that you're impecunious or without funds. Here in the resources section, you can find forms. This is the application for leave to appeal. So the applicant's name goes on the second line there, and under the applicant. So on appeal from, in my case, it says the Court of Appeal for Ontario between myself. In that line, and under the applicant title there, I have appellant, so I'm the appellant, and then it has room for the other party to be named. So this is a PDF document that you can fill out here, and so this is the wrong spot for John Doe. I don't know why I put that in there. I guess I was just testing out whether or not where I put John Doe there, the proper thing to put in there is the applicant's status in the previous court. So the applicant's status in the previous court was, in my circumstance, I was the appellant. And in another case, it could be the respondent on appeal goes in that. So, depending on what the outcome of the previous order was, the court that you appealed from, that will determine what your title was. Here is a very important part of this document, which can only be 20 pages long. It's the Memorandum of Argument. So it has 6 parts or 7 parts. The last 2 parts are not necessary. But essentially, it's good to rely on materials, and that is the last 2 parts. But the first 5 parts there can't be more than 20 pages long. So that's a requirement per the rules or per the Act. And so, fill in the blanks here. And this is this is great that they give you this. For some of the lawyers' forms, they don't give you this kind of a document. It gives you a completely different looking document that gives the lawyer a lot more control. And in this document, what I'm doing is I'm going and I'm filling up all the grounds here. So the Court of Appeal erred in their decision by listing out that error. The Court of Appeal erred in law by that kind of error. The trial judge erred in law, in fact, by... So these are your grounds. Now when we scroll down here now, you'll see we haven't even started the Memorandum of Argument yet. So right here, Part 1, the Statement of Facts. This Part 1 of Facts, Part 1 through 5, I did in Microsoft Word. And I did that for a specific reason. Because in this PDF document, it doesn't allow you to tab. It doesn't allow you to highlight things or indent things. It doesn't allow you to have things bolded. So everything text-wise looks the same. So all the way up to Part 5 here, Orders and Orders Sought, I have in a Word document. And that I have essentially replaced the form that they have given me here. I've made sure that I, put the page numbers where they're supposed to be, and all the titles where they're supposed to be. So everything that's in this document is essentially in my Word document. So that has replaced parts 1 through 5 of this application for leave to appeal. And then in the documents in support, this is really, what's good to note here is that you don't have the opportunity in an appeal to bring forward a lot of fresh evidence. So certificate here, this is a necessity, so this must be filled out. So 23A, I just saw a case online on the Supreme Court website where somebody hadn't filled out their 23A, and the court gave them the opportunity to file this within 30 days. 23B, on the other hand, is if there is some sort of a connection between one of the judges in your case from previous dealings. And that way, this judge may be recused from hearing your case. The reply and motion, so the reply would be if you were the other side, you wanted to reply to this and not necessarily make a cross appeal. The Affidavit of Service is necessary if you are personally serving the person. If you have, the rules say that if you send your originating process, so your notice of application for leave to appeal by registered mail or certified mail, it says that the Affidavit of Service is not necessary. It's good still to have an Affidavit of Service, but essentially what's necessary if you do registered mail or courier is that you have to have tracking results or you have to have a signature of the person that signed. Now that's the only thing that the court rules say as far as service goes. So the other party can be served personally, or they can be served by, so right here is Service Documents, Rule 20. So if you're going to be starting an action, good rule to look at. Service of documents. Any document shall be made on the party's counsel or at the person's last known address by fax or what have you, except documents that are required to be served, except the originating documents. So ordinary mail, except, so 1B here says except originating documents. So all those documents, they have to be in by courier. They have to be either personally served or dropped off at the office to a person at the office of the law firm representing that person, or at delivered personally to the person. So you cannot fax service of the originating documents. That's something else good to note, because those are required to be bound, and documents that are required to be bound under the rules have to be can't be faxed. And the notice of appeal, notice of application for leave to appeal, requires that the document be bound. And mine is bound not in your typical Surlocks, I think it's called Surlocks, the little spiral binding that you see on some kind of on some notebooks. You know, that's a favorite for most lawyers to be binding. I have 3-hole punched my entire document, and I have used what are referred to as brass brads or brass fasteners, and essentially they look like a nail. I'm going to show you the document in another video. And I have, 3-hole punched, and through the 3-hole punch, I have put these brass fasteners. But if you go on Staples' website and you search brass fastener, you will see what I'm referring to. And what has to be on the notice of application for leave to appeal is gray cardstock with the Form 1 photocopied right on the Form 1. So it has to be front and back has to be gray cardstock, and that has to be bound. And it doesn't specify as to what kind of binding, but there's a section on the Supreme Court website as to whether or not there are specifications for a certain type of typesetting. So, 12-point typesetting is ideal. It specifies that it has to be clean white paper for the interior pages. There also are specific color coordination for the covers, and that's all stuff that you can find here on the Supreme Court website just by fingering around. So let's take a look at the guide here. So what is an application for leave to appeal? In a civil case and most criminal cases, you need permission to appeal. And this is just the first step in allowing you in the door of the Supreme Court. It's good to note that the Supreme Court hears applications, or the Supreme Court hears appeals that are typically of national importance, and there are specific wording that it says here on the Supreme Court website. I think I get to that in a minute. But your issues really have to transcend your own case. If it's that you're suggesting that a law has violated the charter, this is a good reason for the court to allow your case to proceed to appeal. There's a second reason for, I don't know if I get to it in this in the screenshot video, but there is simplified procedure. So there's two primary reasons why the court will allow a case to proceed to appeal. It's also good to note that the Supreme Court, they typically have 3 judges reviewing these these leave applications. So this 3-judge panel essentially will have your material scrutinized, and then they will determine whether or not it goes forward or not. And there's no reasons that, this is something good to note, that July is not counted in calculating deadlines. So typically there are 60 days to appeal to the Supreme Court from the date the judgment was pronounced, or the written judgment. And if it was a judgment that was given to you in a lower court in July, the time doesn't start ticking until August. So that's good to know. So what happens typically is that within 60 days, you have to serve a copy of your application for leave to appeal and all supporting material on all the parties who were before the Court of Appeal and are named in the style of cause of your application. A style of cause, I'm not going to get into that now, but that's just the naming of your case. How many parties were involved. Once you serve, then you have to file. All that within the 60 days. And then when you file, that's where the original and 5 copies comes in. That has to be sent to the court, the Supreme Court. So this is all stuff that has to be filed. Your notice of application for leave to appeal, the Court of Appeals reasons for judgment and the order, and the trial court's reasons for judgment and order, and your Memorandum of Argument. You also have to show proof of service, and that could mean that, so proving that service was made on the other side or on all the other parties, that could mean that you need to file an Affidavit of Service, which means that that document would need to be commissioned by a commissioner for taking affidavits. If you're outside the 60-day deadline, you can file what's called a motion for an extension. A motion for extension, you'd have to essentially put together an affidavit. You'd have to put together your whole leave application and your Memorandum of Argument. And then you'd have to, in a separate affidavit, you'd have to give the reasons why it is that why it is that you're delayed in bringing the file to the Supreme Court. Again, I don't know if it's in here, but there's the 2 main reasons why cases will be allowed to proceed. Aside from, editorial reasons or political reasons, cases may be shut down. And there's no reasons given, almost always, there's no reasons given for a dismissal of your leave application. So your application for leave to appeal is typically final, and in rare circumstances can a leave application or a application for leave to appeal may be reconsidered or reheard. So the circumstance that they suggest or that they outline here on their website here, somewhere on the website, is that if the law changed while you were putting together your application for leave to appeal. If the law changed and that affects your case, then it becomes something where the court may, quote unquote, reconsider your leave application. So who do I have to serve? Typically, each counsel or agent for all of the other parties. If the party isn't represented by counsel, the party themselves. That's, standard rule number 1 for any kind of originating document. In this circumstance, though, the counsel is preferred, counsel being counsel that was representing the party at the court of last instance. And what do you have to serve? You have to serve all the documents that start the case, essentially, except some of those other forms that I showed you earlier, the 23A and B. Those forms are just filed with the court. There is another electronic form that needs to be put on a CD-ROM. It's also good to note that with all of your documents, you need to serve a CD, or you need to email, if the other party consents, you need to email a digital copy of all of your documents. So all of your documents that you put together on paper, everything has to be put onto CD-ROM now. Either scanned or, digital documents have to be created. And in PDF is what the court typically looks for. PDF form is pretty much a standard for serving documents nowadays. And all of that has to not only be served on all the parties, but one of these CDs has to be sent along with your paper copies to the court. So when you file your materials, you have to include a CD-ROM of all of your digital documents. So we're running out of, we got about 30 seconds left here of the screenshot video. I'm thinking that we covered pretty much the very basics of, starting a Supreme Court case file. If you're going to be starting a Supreme Court case file here in Canada, comment below, ask some questions on this video, and we will respond to it the best that we can. We can't give legal advice, obviously, so please avoid the word should. Should I do this or should I do that? Keep it generalized. And there you go. A basic scroll through the Supreme Court of Canada's website and some of their basic forms for starting off the application for leave to appeal. Visit the website for the Self-Represented Litigants Society for more information, or check out the YouTube channel that you're watching this video on for more detailed videos on other subject matter. irepmyself.com is the website. Thanks for watching.